Hi everyone, my name is Evelyn Heng and I'm a commercial property solicitor based in the Watford office. I deal with general commercial property work, including buying and selling, landlord and tenant matters, and banking work. And what I mean by banking work is finance and refinancing of commercial, residential, and development properties. And I have experience acting for institutional lenders, private lenders, and borrowers, so I know what to expect from both sides. When I begin my due diligence exercise of the property pack, I would often start by reviewing the property register. I could go on and on about all the possible issues on title, but today I'll focus on a few common ones, consider why they're an issue and how we can mitigate them. Next slide, please. When title to a legal estate is registered at the land registry, there are several classes of title that may be granted. Absolute title, top of the list. This is the best class of title, the most common one, and often granted by the land registry when they're absolutely sure that no one else may claim ownership of the property. Next one is good leasehold title, at least after 2006. It is given where a lease of the property is granted and registered, but a freehold of the property is not registered for one reason or another. For example, a lot of properties are owned by the council, but they're not registered, but they're perhaps the best person to grant you a lease. So you could register a lease. You will be given good leasehold title, but that's because the freehold title is not registered. The next one is possessory title. This is granted where the owner claims to have acquired the land by adverse possession, or if the owner is unable to produce documentary evidence of title for some reason. Qualified title is the rarest of them all, and it's granted where there's some specific defect that's been identified. Absolute title is, of course, the most preferable, but if you have any of the others, you may need to place an indemnity insurance policy on risk to mitigate the risk of your losses if anyone does come along to claim ownership. You should also keep a copy of the on-risk policy with your deeds so that when you come to refinance, sell, or let a property, you have it ready and you will not need to get a new one each time. Alternatively, if you have evidence of ownership, for example, deeds or documents, you can ask your solicitor to apply for the land registry to upgrade your class of title. Next slide, please. A property may be subject to restrictive covenants, meaning you or historic owners of the property have agreed not to do certain things at the property. Examples include not allowing a fence to fall into disrepair, not to use a house as a place of business, or not to use a shop for the sale of, for example, alcohol. Now let's go back to basics with restrictive covenants. You could think of it as two plots of land. Your property is the one that's subject to restrictive covenants, and there's a dominant land who benefits from you complying with your restrictive covenant. If a covenant is breached, the owner of the dominant land may enforce this against you, and this may prevent you from using your property. In turn, this may affect your business. If you are in breach but have not received any notices of breach from the dominant land, one solution is to place a policy on risk. In other cases, it may be worth obtaining a legal opinion, usually from a barrister, to determine where the dominant land is and whether or not restrictive covenants are enforceable. Another way of dealing with this, if you know the covenant's breached, but the use is pertinent to your business and your use of the property, and it is enforceable, it may be worth approaching the dominant land and requesting that they release you by way of a deed of release. Then you can register this at the land registry, so it is known that you are no longer subject to these covenants. Property may also be subject to unknown restrictive covenants. Sometimes there will be an entry stating the property is subject to restrictive covenants pursuant to a conveyance or a deed, but these details are not set out. Perhaps the deeds got lost. The issue with this is that the exact wording is unknown, and therefore by using the property for whatever use you're using it for, you could be unknowingly in breach of these covenants. As such, it'll be best to have a policy in place. Next slide, please. A property may also be subject to, the register will also set out the rights that the property benefits from, and also the rights that the property is subject to. Examples of such rights could include a right of way over private land, a right to enter another property to carry out works to your own property, and rights to lay and connect into services. As a property owner, you'll want to know that your property benefits from all the necessary rights so that you may access and operate from your property. You will also want to be aware of the rights others have over your property so that you're aware of them in advance, and also that you know that how they will affect your use of the property. If the property does not have sufficient rights, for example, rights of way over private land in order to access your property, you may need to enter into a deed of easement with the private land so that you are granted these rights of access. Then you can register this deed at the land registry against your property and the other property so that it's publicly known that you benefit from these rights. Next slide, please. It's also important to check if there are any restrictions on title. Restrictions are there to protect third-party interests. For example, an existing mortgage, overages, a management company making sure you're not selling the property before being paid up to date on service charge, or many other interests. There will be an issue because they may prevent your land registry application, depending on the wording of the restriction. The most common one would say, no disposition shall be registered without certificate or consent from someone. In this case, a disposition by definition would capture lots of transactions, including but not limited to sales, transfers, grants of lease, grants of easements, and legal charges on mortgages. This will be an issue for any future lender, buyer, and tenant because it would prevent the registration of the lender's legal charge, or the buyer's transfer deed, or the tenant's lease. Depending on what the restriction requires, you'll need to deal with this very early on in the transaction, preferably from the very start, really, and line this all up in time for completion, because you'll be dependent on a third party who's not involved in this transaction and who may not be working to the same timetable as you are. If this is not dealt with, this could very well delay completion because the other parties will not want to release any money or complete until they're absolutely sure that the restriction is removed and will not affect their application. If it is clear that a restriction is old and no longer applies, you could ask your solicitor to apply to the land registry to get it removed. Next slide, please. Now let me walk you through a development property that I dealt with recently so you can see how this all comes into play. This transaction involved the transfer of 5 plots of land over 3 separate transfer deeds, and you will note that there's only one access way leading from the back of this row of houses leading down to the public highway. So when reviewing the transfer deeds, I had to consider if every plot of land had necessary rights of access over each other and over the access way as well. I also had to consider if there are any covenants or issues that would affect the use of the property. The transfer deeds also revealed overage provisions, but this was not protected by a restriction on title. They usually are, but this time they're not. In this case, I just advised my client anyway, so that they know not to breach it, and they're also aware of the consequences if they did. The next issue is with the access way, and it's because its class of title is possessory. The previous owner did not have any deeds, so we placed a policy on risk. You will note that this plan is two-dimensional. Upon further investigation on Google Maps and physical inspections, it transpired that there is a flying freehold over the access way, forming an archway over it. And this is owned by a third party. The most obvious danger is that what happens if the structure collapses or falls into disrepair and then blocks the one and only access way to the rest of the property at the back. So I had to consider if the owner of the access way had sufficient rights and provisions allowing them to enter the flying freehold to carry out maintenance work. Also, I had to consider if there were sufficient covenants in place preventing the owner of the flying freehold from doing anything that may block the access way, and also positive covenants to make sure that they keep the flying freehold in good repair. To hold this all together, we also got a policy in place Now, this is quite a unique situation, so we had to get a bespoke policy. This covered the event where we are prevented by a third party from accessing the accessway and the flying freehold and preventing us from carrying out works. Next slide, please. So I've covered a few things today. I've covered class of title, restrictive covenants, rights and easements and restrictions. We also went through a property with a combination of these issues. Now, depending on the type of issue, it will be dealt with by a number of ways, whether it's an indemnity policy, applications to the land registry, deeds of easements, or release. I know I mentioned indemnity policies a lot today, but please note that indemnity policies are not a fix-all solution. They do not remedy the defect, and they can mitigate the risk of any losses that may be suffered. It does depend on the facts, depends on the terms of the insurers and whatever's available on the market. Saying that, lenders heavily rely on policies. Sometimes, if the policy is a few £100s, which may be less than 1 to 2 hours of your lawyer's time spent arguing about it, it may be worth just putting it in place. If you take anything away from today, please consider dealing with title issues early, at the very start of the matter, if not before, otherwise it could very well delay completion. Thanks for listening.
Evelyn, that was really informative. So good afternoon, everybody. My name is Sarah Holly, and I'm an associate in the construction team here at VWV. So I'm going to spend the next 15 to 20 minutes talking you through some practical points on construction law through the lens of fit-out works. I've chosen fit-out works to talk about because more often than not, when we're giving advice in commercial property transactions, there's an element of fit-out works happening. And what I mean is where we have a shell that's already built and works are happening to the internal element of the shell. But legally speaking, fit-out works are dealt with in the same way any works are dealt with. So both are considered construction operations for the purposes of the Housing Grants, Construction and Regeneration Act. This is a practical session. I'm not actually going to quote any more statute or case law, just looking at an overview of construction generally, and then my top tips in relation to fit-out works. So we're going to look at 4 things. So overview of construction projects generally, overview of construction contracts, a bit of design and build procurement, and then bringing it full circle round to fit-out works. Next slide, please. So this very creative slide here, this is just the best I can do, shows the lifespan of a project. So we're starting with project inception, where someone has the great idea to carry out some fit-out works or an office refurb. And at this stage of the project, we'll be looking at how all the parties are going to be procured, whether tenders need to be issued, and etc. And then we move on to the design. So this is the appointment of the design team, and then that design being carried out. We then move on to the works period where the contractor is appointed and then the works start and they're carried out. And then at the end of those works, we hit practical completion, and then we enter into the defects liability period, or also known as the rectification period, to resolve any immediate defects. And then following the expiry of that period, we then go into the limitation period, which would be 6 or 12 years, depending on whether the documents are executed as deeds or if they're signed underhand. And the limitation period is important, in particular on construction projects, because this is where we might know whether there are any inherent defects that have arisen in the design or the build of the works. And so in relation to commercial property transactions, usually property and construction, we overlap at the point where permission is being sought for works to be carried out. So this might be at the point of the agreement for lease, or a license for alterations, or the lease itself. And what we can see is and hopefully it's clear on the screen, is that the appointments of the design team and the building contract, they are running concurrently with those property documents. So the property documents might be negotiated towards the beginning of a project, but they might be talking about issues that are relevant towards the end of a project. And a good example of that is practical completion. We would want all of the property and the construction documents, where possible, to mirror terms. There would only be one practical completion on a project, and that would need to be the same across all the documents. The other point that we can look at from the lifespan of a project is that the liability of the parties, so the designers and the contractor themselves, lasts a lot longer than just the duration of the works or services being carried out. For example, if you've got a limitation period that's 12 years, from the moment from project inception to the 12-year limitation period, that could end up being like 15 years, depending on kind of the extent of the works being carried out. And with fit out works, and with every set of works, there's less, like more simple works that could be carried out, or it could become quite complicated. So what we're interested in is that the liability lasts much longer than the works being carried out, and the construction documents and the property documents, there is an overlap between them. They do need to interact and mirror as much as possible. Next slide, please. So now we're looking at an overview of construction contracts. And what do I mean? So for the purposes of this talk, I'm just looking at building contracts and professional appointments. So a building contract is where an employer appoints a contractor to carry out works. And there are lots of standard forms of building contracts that are commonly used. The two most frequently used are JCT and NEC. And within those suites of contracts, there's multiple different options depending on how the works and the design are being procured. In terms of professional appointments, that's where the client or the employer appoints consultants to carry out services. So that will be the appointment of the design team, so the architect, M&E engineers, etc. But it might also be the appointment of, for example, a project manager, so a consultant that's non-design. There are standard forms depending on kind of the services that are being appointed, but more often than not, we do see bespoke forms of professional appointment. And the reason why we're particularly interested in the construction documents is because they allocate the risks between the parties. And most, if anyone's familiar with JCT, for example, it's quite a big contract. It's quite a lot of pages to it. It's very detailed and what looks at first instance quite complicated. And the reason for that is because there's lots of different things that can happen throughout the duration of a project, which makes it more complicated. And the contract has to respond to each of those likely events. So, for example, the length of the project, it might be planned to be 6 weeks if it's simple fit out works, but if something complicated arises, it can end up being 6 months. So the building contract has to respond to delays. Also, some works can be very complicated, and that's looked at in the building contracts, the size of the project, and I suppose the biggest one is the value. So on day one, the value of the work, so the contract sum might be, I don't know, £50,000, but by the time that works are finished, what has actually been paid, and it's likely to probably be a bit more. And so the building contract has to respond to all those different mechanisms. And the question we discuss a lot with clients at the beginning of transactions is, well, where does that additional risk sit? Should it sit with the contractor? Should it sit with the employer? And that is what the construction documents do. They allocate the risks between the parties. There are many other different types of contracts that you'd see in a construction project, for example, collateral warranties, letters of intent, lots of different things. But just for the purposes of this, I'm only looking at building contracts and professional appointments. Next slide, please. So this brings us on to a bit of construction procurement. Hopefully that doesn't scare you, that word, too much, procurement. But what I mean is how the works are being appointed. So there's two common models, and they're both on the screen. So the first one is the design and build procurement model. So in this example, the developer is appointing the main contractor, and then the main contractor will then appoint the design team, so the architect, structural engineer, and MEP engineer, and also its subcontractors. So in this model, the design is flowing through the main contractor. And so the main contractor is essentially taking the design liability on that project for that procurement model. So in comparison, we have the standard procurement model, and that's where the developer is appointing the main contractor, who will appoint its subcontractors, but the developer is also appointing separately the architect, structural engineer, and MEP engineer. So in this model, the design liability isn't all flowing through the main contractor. It's actually each party that is carrying out design is responsible for its own design. This is important because it makes us understand where all the liability sits and who's taking responsibility for what in a project. So with fit-out works, relatively like low-level, low-complex works, there might not be a huge element of design, but some fit-out works can include quite a lot of design, and we would want to know where that liability sits. Next slide, please. So on this screen, we're going back to the lifespan of the project. And we have the design team being appointed in the design stage, but the building contractor is only being appointed at the works commencement stage, for an example. So if we appoint a contractor under a JCT design and build contract, which is the design and build procurement model, you would imagine that the main contractor would be taking liability for all the design, and they are, but they're only taking liability for all the design from the point that they have been appointed. So any design that has been carried out before they've been appointed will still be the liability of the party that carried out that design. So there's holes in the procurement method, and as lawyers, we like to fill those holes essentially. But if you're carrying out a fit-out works project, I think the key message is understanding who is designing the works and who is building the works, so that you can be very clear about where the liabilities sit and how risky each of the contracts are. Next slide, please. So now bringing this full circle back to fit-out works. And these are just my general top tips, really. So first point is acknowledging whether design is, who's doing the design and who is doing the building, which I've mentioned before. And I think on more complicated matters, those questions are addressed, and less complicated matters, sometimes the design can get a bit overlooked, but the design is still just as important as the building, the construction works themselves. Second top tip is project management. So where I've explained that there's lots of risks under a building contract, essentially effective project management does help mitigate those risks, because it will allow us to kind of reduce delays, costs, and disputes. So it does help kind of mitigate those risks. The third point is contracts. So are your contracts in order? Do you have contracts? If you have a funder involved, the chances are that they will want collateral warranties, and so you won't be able to get away with not having your contracts in order. And then the added limb is, are your construction contracts then compliant and working with your property documents? And then the final point here, and this is probably the mic drop moment of fit-out works, is the insurance. And this is probably the biggest practical point to consider, is how is the existing structure being insured? So the existing structure is the shell of the building, and you might be focused on the insurance of the works, but what happens if something happens to the existing structure? Who is insuring that? And the JCT, for example, they have a standard way that it's expecting insurance to be taken out and maintained. But it might not be that you have that insurance, because that insurance is quite costly. So it's worth kind of figuring out exactly who's insured and what the risks are in relation to insurance. The added complexity is where you might have a multi-let building. So if you're a tenant and you're taking a lease of just a single floor, and the shell essentially is the whole building, the landlord is going to need to be involved in those insurance discussions. And then the final point is, if depending on what the insurance arrangements are, does the construction contract reflect what those insurance arrangements are? So if it doesn't, and the contract is expecting certain insurances to be taken out, but in practice different insurance has been taken out, or it's being taken out and maintained by a different party, the contract is wrong. And so just avoid kind of being in breach almost at the beginning of a contract. And I think in terms of insurance, what we find as the lawyers when the contracts are passing our desks, this is one of those things where it can sometimes go in the too hard box and get left to the last conversation. And sometimes it can delay the contracts being entered into. So my biggest tip is to kind of face the insurance questions head on at the beginning of a matter. Next slide, please. And that's it from me. Thank you very much.
Thanks very much, Sarah. Good afternoon, everyone, and thank you for joining our Commercial Property Update webinar. My name is Rory, and I'm a Senior Associate in the Commercial Property team at VWV. Today, I'll be providing you with a brief update on leasehold reform, specifically the proposals put forward in the Commonhold white paper published by the government back in March. In Labour's own words, they want to completely overhaul and bring to an end what they see as a feudal leasehold system. The Commonhold white paper sets out their strategy for reforming this system and implementing Commonhold as a default tenure for flats. It's a significant change which has the potential to really disrupt the property industry. Next slide, please. To quote Matthew Pennycook, the Minister of State for Housing and Planning, at the heart of the Commonhold model is a simple principle. The people who should own buildings and who should exercise control over their management, shared facilities and related costs are not third-party landlords, but the people who live in flats within them and have a direct stake in their upkeep. It's a seemingly worthy goal and something that many think makes a lot of sense, although of course there are others who argue that these reforms are unnecessary and unrealistic. Before we get into the proposed reforms, what exactly is Commonhold and how does it differ to leasehold? Next slide, please. Property in England and Wales is owned either on a freehold or a leasehold basis in general. Now, there are actually a small number of existing Commonhold properties, but I'll come back to that in a bit. In the most simple terms, freeholders own the property and the land the property is on forever. Leaseholders, on the other hand, own their property for a fixed amount of time, leasing it from a third-party landlord, usually the freehold owner. Leaseholders don't necessarily own their property or building. They are just granted an interest and right to use their property for a fixed period of time. With leasehold interests, ownership of the property then reverts back to the landlord when the lease comes to an end. Commonhold is a distinct type of freehold ownership, where individual property owners each own their unit outright with no expiring term. Together, they share ownership of the communal areas through a Commonhold association, which is a company that they are all members of and jointly control. Commonhold is specifically designed to be owned, managed, and looked after without the involvement of a third party. So there is no landlord and no separate freehold interest. In Commonhold ownership, there is no lease. The Commonhold Community Statement is a legal document that defines the rights, responsibilities, and rules for all unit owners within a Commonhold. The CCS also provides the governing framework for the Commonhold Association, outlining how the shared areas and facilities will be managed, maintained, and funded. In short, the government believes that Commonhold is a purpose-built, democratic framework for shared living, designed to simplify ownership and eliminate the complexities and perceived unfairness often associated with leasehold arrangements. Next slide, please. So what proposals are contained in the white paper? I mentioned earlier that you can actually find some Commonhold flats in England. So Commonhold as a legal tenure does therefore already exist. It was introduced in the early 2000s, inspired by the experience of other jurisdictions such as Australia and the USA, where land holdings similar to Commonhold had operated successfully for decades. Despite being introduced over 20 years ago, however, there are fewer than 200 Commonhold units within around 20 Commonhold developments throughout England. It's incredibly rare, so why has the use of Commonhold not taken off? Well, the lack of popularity is due to a number of reasons, such as a slightly restrictive and complicated approach to creating Commonholds, resistance to change in the market, and an unwillingness by some lenders to offer mortgages on Commonhold titles due to perceived deficiencies with the existing Commonhold model. The main thrust of the white paper is therefore to set out how the government intends to reform and rectify issues with the existing model so that it can then push for its use as a default tenure of flat ownership, eventually replacing leasehold. But leasehold has been used as a go-to tenure for flats for decades. It's well established and well understood by the property industry. Additionally, given Commonhold's lack of popularity until now, what benefits does it confer over leasehold exactly? Next slide, please. Well, advocates of Commonhold may point to a number of advantages with its use. Firstly, the lack of a fixed lease term will be much more attractive to buyers and lenders, with no risk to the value of Commonhold's unit going down over time as the lease term gets shorter and close to expiry. Secondly, many believe that the democratized model may give common holders more of an incentive to participate in the running and administration of their shared properties. They will be able to collectively make decisions and directly shape the way that their property and shared space is operated, hopefully fostering a community that is right for them. Thirdly, leases can be very complex, even for property lawyers, and a simplified system with standard rules and procedures, which can more easily be understood by non-property practitioners, should help in opening up and streamlining the process of buying and owning shared property. Fourthly, there may be benefits to developers too, providing them with a convenient and efficient means of exiting the development once complete. Unless and until the developer can dispose of the freehold interest in the new development, they will retain ownership of a property in which they have very little interest, but are required to continue to act as landlord to the leaseholders. Landlords' interests often do not align with leaseholders' interests, so vested control over the common parts at an early stage may be preferable to both parties. Finally, and I think this is a fairly important point for the government, leasehold has unfortunately been subject to fairly extensive criticism of late, with many seeing it as unfair, obsolete, and feudal, as I said earlier. With its reputation in the doldrums, a move to Commonhold, perceived to be a more democratic model, may inspire more confidence in consumers and the property market. Of course, there are some valid criticisms of Commonhold too. For example, there are currently inadequate means of pursuing common holders who do not pay service charge costs. Whereas the lease can be forfeited if a leaseholder does not comply with the lease terms, a Commonhold unit can't be forfeited. This can make it difficult for Commonhold associations to pursue unit owners for unpaid sums, placing the building at risk of financial failure. One proposed reform is to allow the Commonhold Association to apply to court for an expedited power of sale to recover such monies. Conversely, though, some see the lack of forfeiture as a good thing, particularly lenders who worry about losing their security over leases if they're forfeited. Secondly, the current Commonhold framework is not flexible enough for large developments, such as those built in phases or containing a larger proportion of commercial units. The system will be reformed to allow Commonhold developments to have different sections, so different Commonhold titles within a larger development. This is to provide developers with more flexibility and planning in planning and building out a large, complex development. Next slide, please. There are plenty of other changes considered in the white paper to make Commonhold more attractive. But if the government is able to push Commonhold as a viable model going forward, well, where exactly does that leave existing leaseholders? The government acknowledged this will be a tricky issue to resolve. The current conversion model requires full consent from every party involved. So the freeholder, every leaseholder, and every lender to every leaseholder. And the process of conversion requires leaseholders to buy out their leases, likely to be prohibitively expensive for many. The Law Commission is proposing that the consent threshold for conversion to Commonhold be set at 50%. However, this then has implications for leaseholders within a block who do not wish to or cannot afford to take part in the conversion process. These are known as non-consenting leaseholders. That then raises a question: how do you deal with a block comprised of Commonhold unit owners and non-consenting leaseholders? The Law Commission is proposing two solutions. Either those leaseholders who choose not to participate in conversion are allowed to continue living as leaseholders, subject to the terms of their original leases, with their leases to be phased out over time and replaced with Commonhold at certain trigger events. Or alternatively, non-consenting leaseholders would be required to convert, but given an upfront equity loan funded by the government to pay for the conversion. This approach would at least mean that all homeowners in the building are Commonhold unit owners from the point of conversion. Clearly, both proposals have certain drawbacks. In a development with a mix of Commonhold unit owners and leaseholders, it's likely going to be very difficult to manage, with different rules, different legislation affecting different occupiers in the same building. A hybrid Commonhold and leasehold building may very well be worse than the leasehold it's seeking to replace. Under the second option, however, this is only going to be achieved at great expense. Another significant concern is that the introduction of Commonhold will create a two-tier market, with those existing leasehold properties plagued by historic issues being seen as less attractive to potential buyers. Two such issues, for example, are existing ground rents and short lease terms, which need to be extended at great cost to leaseholders. If we look at ground rents specifically, these were actually banned for all new leasehold properties back in 2022. Introducing Commonhold isn't actually going to make any difference at this point, but neither will it address the existing ground rents payable by a large proportion of leaseholders, some of which continue to escalate and cause leaseholders with great difficulties when they try to sell the property. The white paper is curiously silent on the issue of existing ground rents, despite the government promising to tackle unregulated, underfundable, and unaffordable ground rents. It's still not clear how or when the government intends to deal with this. Unless and until such issues are addressed, however, many existing leaseholders will still find themselves in a difficult situation as more new properties enter the market which are not subject to ground rents, short lease terms, or apathetic freehold owners. Some therefore argue that our time and resources would best be spent continuing to reform the existing leasehold system to try and put all leaseholders on an equal footing, rather than overhauling it entirely. To some degree, it's irrelevant whether we have leasehold or commonhold. What matters is that we have a working system in place which allows owners and occupiers of shared spaces to effectively manage those properties. Next slide, please. So what's next for leasehold and commonhold reform? Following the white paper, the government intends to publish a draft commonhold reform bill in the second half of this year. The purpose of publishing the draft bill prior to submitting it to Parliament is to invite scrutiny and comments by others, and so that the property industry can start thinking about how to change their business practices to prepare for the delivery of commonhold at scale. The government will also consult on the best approach to banning new leasehold flats and seek views on what transitional arrangements may be required to mitigate any disruption to new housing supply, given their pledge to deliver 1.5 million new homes. Ultimately, the intention, therefore, is to ensure that commonhold works before making commonhold the default tenure going forward and banning new leases entirely. However, even given just some of the issues we've discussed today, I think this is going to take some time, so I don't see these changes being implemented in the short term or even perhaps the medium term. Furthermore, with so many new laws being passed or considered, the current situation is confusing. The Leasehold and Freehold Reform Bill, for example, which became an act just before the general election last year, contained many provisions to reform leasehold law, attempting to put leaseholders on a better footing. This included rights around buying out ground rents and making it cheaper and easier to extend a residential lease. However, many of the provisions of that act have not actually come into force yet, and so cannot be relied on by leaseholders. Secondary legislation needs to be passed to implement these provisions, and the current government is still working towards reforming this. Again, perhaps the focus should be on dealing with this for the benefit of existing leaseholders. The government, I think, will have a very hard task in managing and communicating these reforms, not just to the property industry, but also to the wider population and those who will eventually buy and live in Commonhold properties. If the government are able to successfully implement these changes, they are, however, going to significantly disrupt and change the residential property industry. All property practitioners, lawyers, developments, agents, and lenders will need to become familiar with the Commonhold model. So it'll be important to monitor these reforms going ahead and understand their impact. I will certainly be keeping a close eye on developments in this space and would encourage everyone else to do the same. Well, I hope that you found this presentation interesting. And if you have any questions, we'd be happy to answer them now or afterwards. Okay, well, thanks everyone for attending. It's question time. I think the first one we have is for Evelyn, if that's okay for you, Evelyn.
Yes, that's fine. Let me just read out the question for the benefit of the recording. If the original title deeds are lost and the land registry has only issued possessory title, how would a landowner go about upgrading the title to title absolute? So there's a couple options here. I think you would need to gather up further evidence of your title. It doesn't have to be deeds. It could be evidence of receipt of income from the land, anything related to the property at all, while you're there, while you're occupying it, and also perhaps statutory declarations and other documentation. Then you can apply for an upgrade. So you should make an application to the land registry with whatever you have. Then the land registry will review and make a decision based on the evidence supplied. But if you cannot get any further evidence of title, then you'll have to wait 12 years. You'll have to have possessory title for 12 years and apply to upgrade the title. And yeah, your solicitor should be able to help you on this one. The form, I think it's called UT1. Yeah, the land registry the land registry guidance is actually public. It's on the gov.uk website. So if you have any questions, you could look at that independently if you like, or instruct your solicitor to do so. Thank you so much.
Thanks, Evelyn. We've had a question on the white paper. The question is, does the white paper propose that this will also affect leasehold, residential, semi-detached, detached homes, or just residential? Well, the proposal is to ban residential flats, so I don't see it having a direct impact on residential, semi-detached, or detached homes, because those would typically be sold and owned on a freehold basis. So, but you refer to just residential, it will relate to commercial property as well, if that commercial property forms part of a wider development, a mixed-use development with other residential uses. So part of the purpose of the Commonhold white paper is to look at how the existing model works and it doesn't work. And one of the issues is it's a bit too restrictive for larger developments where you do have a mixture of commercial properties and residential properties. So the idea is, how can we separate those out? How can certain parts of development form their own Commonhold titles? what are the lenders' views on Commonhold? I'm not sure about any specific views. I think that lenders are generally in favour, but I think they have a lot of reservations regarding the existing model. So as I said, part of this exercise by the government is to look at the existing model and then reform it where necessary. I mean, this exercise has been going on for quite a few years now. Back in 2020, the Law Commission looked at Commonhold, and they've prepared a raft of proposed reforms to the existing Commonhold model. So I think one of the tasks of the government is going to be try to convince lenders and banks that Commonhold is going to be a viable form of security if they want to push this. So somebody's asked, please can you explain how Commonhold works in terms of implementation? What rights does one common holder seeking to enforce maintenance requirements have if another common holder is not willing to participate? So my understanding, and I'm not particularly in favour of the existing Commonhold model, given that it's so scarce and rare. But essentially, on the sale of the first unit in the Commonhold, that would then establish the Commonhold title. This then causes issues so Commonhold is quite useful for smaller developments, but that can cause issues for developers if they're trying to build out a large scale, complex multi-phase development. So again, that's something that the white paper and the government are looking at. How exactly and when should the Commonhold title be created? What rights does one common holder seeking to enforce maintenance requirements? So you'd be looking at the Commonhold Association seeking to enforce the obligations and duties of each individual common holder against that common holder. Again, there have been difficulties to understand with enforcement, and again, this has been looked at the white paper. Somebody's asked about Commonhold in other countries. Please explain how it differs there compared to the UK. I'm afraid I don't quite know how those particular jurisdictions operate. I mean, what I would say is it's clearly operated in those jurisdictions for many, many years. So I'm sure the government will be able to take a lot of inspiration from those particular experiences. Somebody's asked which of the provisions of the Leasehold and Freehold Reform Act 2024 are now in force. I'm afraid I don't know off the top of my head. I'd be happy to go away and check. I think I'm pretty sure it's been fairly limited up until now, but I haven't checked recently. Okay, so I think that's most of the questions answered. Well, thanks everyone for attending. I hope you found it very interesting and worth your time, and hope to see you again soon. I do have to do a plug-in for an event we're holding for our clients and contacts in our London office. That's going to take place on the 19th of June, 6 p.m. to 8 p.m. So we hope to see you all there. So thanks everyone again for your time, and enjoy the rest of your day.